My name is Derry Wong. I am a barrister called to the Bar of the Supreme Court of Hong Kong in 1981. I practiced for many years in Hong Kong. I had also been a law professor. I now report to the international community as to my experience in respect of the rule of law in Hong Kong. I particularly refer to one very serious incident. In 2011, or rather in 2009, I was facing a disciplinary proceeding instituted by the Bar Council of the Hong Kong Bar Association. The Bar Council is the governing body of the Hong Kong Bar Association. The disciplinary proceeding was in respect of some of my submissions made in a judicial proceeding. In that year, on the 24th of August, I was coerced by a very senior and prominent barrister called the Senior Counsel in Hong Kong. He passed on to me an offer made or allegedly made by the legal representative of the Hong Kong Bar Council. That legal representative himself is a senior counsel. The content of the offer is as follows. In return for my apologizing to the relevant judicial officer who decided the matter initially, and in return for my withdrawing certain grounds of appeal to the Court of Appeal in a pending appeal, I was promised that the disciplinary proceeding against me would be terminated and there would be no application for legal costs against me. That offer is in clear breach of the Hong Kong Bar Code, that is the Code of Conduct for Hong Kong barristers, and also in breach of the criminal law, as they involve grave offenses. The possible offenses are attempting to pervert the course of justice, conspiracy to pervert the course of justice, and incitement of me to conspire with them to pervert the course of justice. Those are very serious offenses. In respect of this particular incident, I complained to the Hong Kong Bar Council. After procrastinating for 14 months, I was told that there was no breach of the Bar Code, even though the Bar Code provides explicitly and very distinctly that no barrister, no lawyer can prejudice the administration of justice in Hong Kong. That is fundamental. That conclusion is repugnant to the clear terms of the Code of Conduct and completely groundless, if not ridiculous. Pursuant to the law, I applied to the Chief Judge of the Hong Kong High Court to consider the matter afresh and to make an order against the Bar Council to start the disciplinary proceeding against the counsel who threatened me, as I mentioned just now. The application is pursuant to Section 35(2) of the Hong Kong Legal Practitioners Ordinance. The application was made by me 4 months ago. Apart from acknowledging receipt of my application, the Chief Judge of Hong Kong had made no substantive reply. I have no idea as to what he wanted to do. Does he want to follow the law or not? If not, then this would be a very clear signal of a decline in the rule of law of Hong Kong. I now call upon him to comply with the law, not to protect anybody, and not be seen to be allowing anybody to be above the law, however prominent he may be. He represents Hong Kong and is symbolic of Hong Kong's rule of law. So I call upon the international community to pay attention to how judicial officers and the governing body of the Hong Kong Bar Association behave in the context of the rule of law in Hong Kong. Thank you very much.